share that.
Are we sure to share? Good morning. I'm Judy Lipton. I co-direct our clinical program here at Case Western Reserve, and I am pleased to introduce our first panel this morning. We're beginning today's symposium with a discussion of government control of law school curricula, and in particular of law school clinics. Law schools and academic programs throughout our universities are increasingly requiring real-world experience. They want students out in the community doing real work to bridge their development from the classroom to the community. In law schools, this has taken the form often of in-house clinical programs taught by full-time faculty in which law students certified by state Supreme Courts have represented real clients. Our panel this morning will discuss recent efforts of legislators and corporations to control and influence the choice of cases that clinics make, and therefore to fundamentally challenge the limits of academic freedom and to de-lawyer and limit these clients' access to a meaningful voice in the courts. This has largely been an invisible problem, I think, and I'm happy that we're starting the symposium with this issue because it goes so fundamentally to the limits of academic freedom and to the ability of lawyers to help citizens to have a meaningful voice. I want to introduce our panel and then I'll let them take over. They are very well prepared to take on this issue. First is Peter Joy, who is currently the Vice Dean at Washington University School of Law in St. Louis, but has been in clinical education for a long time, starting here at Case Western Reserve. He has written in this area of limitations placed on clinical education for some time and has focused his teaching on professional ethics as well as clinical education. Next is Adam Babich, who is the director of the clinical program at Tulane University. Professor Babich is, I don't know, unfortunately or fortunately, at the very heart of legislative attacks on clinical education. He'll be able to talk to you about the experiences at Tulane when legislation was introduced to actually defund the university unless it closed its clinical program. Professor Entin teaches here at Case Western Reserve and will then comment on Professor Joy and Professor Babich's presentations, and we'll hope to open it to all of you to join us in addressing this incredibly important issue. Thank you. Peter, you going to begin?
Sure. Good morning. It's a pleasure to be back here, and I couldn't help but think of a couple of things when Dean Koo was giving his introduction. He was talking about the power of the government, and I just completed a historical novel set in the mid-1500s, and there it seemed that the king used the rack quite a bit to extract the kind of compliance that he wanted. Unfortunately, no matter how bad the politics are today, we haven't gone down that road, or at least not yet. It's also very nice to come back, and I was thinking this morning, I'm staying at the Glidden House where the law school clinic was located when I first started teaching here. If anybody does land use planning, I'm sure you're probably thinking it's being put to a better and higher use now. But we were fortunate to come into the law school, and I worked here without a break in service from 1981 to 1998, and I was thinking I probably spent more waking hours either in this building or in the Glidden House than any other single place in my entire life. So it's nice to be here. I'd like to start to sort of put some things in context and to begin by asking a question of everybody. How many people have been to Washington, D.C.? Just raise your hand. Okay. Now, put them down. Now, how many people, when you went to Washington, D.C., went to where the Supreme Court is? Okay, maybe about half of everybody here. Well, if you went to the Supreme Court and you looked at the Supreme Court, there's a motto that's chiseled into the limestone across the top of the Supreme Court. Does anybody remember what that motto says?
Equal justice under law.
Equal justice under law. Now, there's a story that the reason why that motto is there is the architect was told, come up with, some kind of a motto that would fit this building that'll be the highest court in the land, and that was the one that fit in that space. I like to think that that's probably just an apocryphal story and not a real story, and this concept of equal justice under law is supposed to be a meaningful concept. But if you think about equal justice under law, you realize that the way you actually get heard is by getting into court, and the way you get into court is by having a lawyer. And without a lawyer, you're not going to actually be able to be heard. The only place where you have a right to a lawyer consistently are in criminal cases. And another historical interesting fact is at the time of the founding of this country in England, you didn't have a right to a lawyer in criminal felony cases. And that was one of the revolutionary ideas in this country with the Sixth Amendment. Now, it took a while for the Sixth Amendment to be interpreted to grant a lawyer in the full range of criminal type matters that we have today. But if you think of it, that, in England, a couple hundred years after the rack was the most common technique in use, they didn't want lawyers interfering with the legal process. So whatever justice was meted out was definitely very swift and sure, and again, probably reflected the will of the government in the eyes at that time, the king. So there weren't any lawyers. And what law school clinics have done, and we'll talk a little bit today, is help to fill the gap to provide legal representation in a variety of instances for people who otherwise wouldn't be able to have lawyers. And so I'm going to talk a little bit about the concept of interference in law school clinic case and client selection, the history, to put some of this in context, talk about the chilling effects, and then talk about some strategies. But I want to start by saying that the issues of academic freedom, government speech, those are, when it comes to the First Amendment, very murky concepts at best. The law is not as definite as one would like. Sure, you could point to a few Supreme Court cases that talk about academic freedom being a special concern of the First Amendment, but special concern somehow isn't defined in terms of a definite absolute right. So there are some limitations. In terms of this access to justice mission, there have been some type of clinical programs in some law schools ever since there have been university-based law schools in this country. So dating back to the late 1800s and the early 1900s, there were what were called legal dispensaries at some law schools where faculty and law students volunteered their time and represented indigent people, people that couldn't afford lawyers. I've done a little bit of investigation, and at that time it appeared that whoever the judge was could allow whoever the judge wanted to represent people, and law students did a lot of work, and faculty did some work. But it was really in the mid-1960s with, for those of you who have hair about the color of mine, if you still have hair, you could probably remember that there was a call for a lot more relevance in legal education. As Judy Lipton had indicated, somehow putting the theory learned in classrooms into practice, into helping people. And in the late 1960s, through Ford Foundation funding, a number of law schools started clinical programs. The clinical program in this law school as an in-house program started in the mid-1970s. Prior to that time, there was a cooperative effort with the Cleveland Legal Aid Society, and Professor Derschlag was someone who was an early pioneer of working with students in that capacity, having worked with the Legal Aid Society of Cleveland and then the law school. And eventually the clinical program here, and the clinical programs of a lot of schools became much more an academic component of what goes on. And so we find today that there are in-house clinical programs in almost all of the 204 ABA-approved law schools across this country. And a survey of a year and a half ago demonstrated that clinical programs are serving over 120,000 clients, providing more than 2.4 million hours of free legal services. And so if you take a look at what clinical programs across the country are doing in a cumulative way, they're really contributing toward making that phrase, equal access under law, a meaningful phrase. But what do we mean by political interference? And I think this is probably a time where, that story about a picture is worth 1,000 words. Well, maybe a short film clip is worth 10,000 words. And so I'd like to show you something. This is a film clip that deals with an instance of political interference that was probably one of the most prominent ones, dates back to the late 1990s. It does involve Tulane. Tulane, as you'll hear later, has been, I guess, at the epicenter of political interference. And I think that this film clip will provide for everybody a little bit of context for what we'll be talking about on this panel. So.
Look at another legal battle, one that is less evenly matched. It's a David taking on a Goliath. David won the first round, but as CBS's Richard Schlesinger reports, this showdown's not over.
Halfway between New Orleans and Baton Rouge, in Convent, Louisiana, fields of sugarcane are ringed by chemical plants. The issue is, are they nourishing the area or eating it away?
We got plant there, we got plant there, we got plant there, all over. We surrounded by plants.
A large group of people here, mostly poor, mostly black, has been complaining about the plants for years, wondering about the smells, worried about the air.
It'd make you nauseated, get the goat scratching, eyes running water sometimes.
When a Japanese chemical company announced plans to build a new plant on almost 4,000 acres here, Gloria Braxton and hundreds of her neighbors went out and retained the highest-powered attorneys they could afford to stop it.
It's kind of an ego boost to us because it's kind of like we're their last hope.
Actually, they're not quite lawyers. Richard Esnicios, Aurelia Merchant, and Jennifer Lewis are law students. They work at a Tulane University legal clinic, giving free help to clients too poor to pay. Richard, Aurelia, and Jennifer took on big-time industry and its big-time lawyers.
They have the power and the money, they have advertising firms, and they have consultants and things like that.
What do you guys have?
Just us.
They may be young and green, but they were good enough to turn the corporate lawyers gray. They successfully challenged key permits for the plant, at least delaying, possibly derailing the $700 million project. In the process, they made enemies of business leaders and the governor, who called them vigilantes and outlaws, among other things.
They're the big guys that have got the courts figured out. They can stop development. So I'm the one that feels
They're the big guys?
I feel they've got the stroke. They're winning. They're going to run this industry off. They're the bullies.
They're law students.
We're supposed to zealously advocate for our clients, and that's what we're trying to do, and that's what we do.
So why do you suppose the governor of the state of Louisiana is calling you vigilantes? What else? Bandits.
To me, it was the first indication that we must really be doing our job right.
How important is the law clinic at Tulane?
I love them because they're helping us. I love them.
The governor has tried to enlist Tulane alumni to help him rein in the clinic, and he's threatened the university's tax exemptions if they don't. After the governor and industry leaders objected to the law clinic's work here, the Louisiana Supreme Court issued some unprecedented restrictions, which could prevent clinics from ever taking a case like this again. Both sides agree on one thing: tying the hands of the lawyers will make life a lot easier for the chemical industry.
Why is it that the governor don't want the lawyer to help us? He's rich, and he don't care about the poor people.
But Governor Foster believes the law clinic is working on behalf of people here who don't deserve the free help.
My suspicion is that a whole bunch of the people that are involved in this litigation are not indigent.
They're not poor?
No, I don't think so.
Hell, if we wasn't poor, we wouldn't be here. Don't you think if I could pack up like some of these people doing, and get away from here, mister, I'll be gone.
The law clinic is still in business, still representing people here.
If students weren't representing these people in convent, no one would.
Now the students have a new case to argue, their own. They're fighting the tough new restrictions on their activities, learning in the classroom and the courtroom what happens when you take on big business in a place like Convent. For Eye on America, I'm Richard Schlesinger in Convent, Louisiana.
And that's part of our world tonight.
I mean, rather than me try to spend a lot of time explaining, I think that capsulizes a lot of what it means in terms of trying to represent people who traditionally don't have representation. And what's happening in terms of this reaction to clinical programs that are providing opportunities for people who otherwise wouldn't have their claims heard has not just been something that's focused on legal clinics. The Legal Services Corporation has faced a number of restrictions imposed on what they could do, and there have been other attacks on public interest lawyers who try to provide access to the courts. There have been more than 35 major instances of some kind of political interference in clinical programs that I and others have been able to document over the last 40 years. And what I mean by major are not the things that every clinical program experiences. And I'll just mention a couple that occurred during the time that I was teaching here at Case Western Reserve to give you an idea of the things I'm not counting as major. So there was a case that actually Judy Lipton was involved in, where the law school clinic represented a woman who we started off representing her when she was stopped for driving under the influence in a parking lot of a hotel. And she was middle-aged, professional, never arrested, never stopped for anything in her life, but she was stopped for driving under the influence, and the police brought her to the jail in Beechwood, Ohio, and then subjected her to a strip search. The law students who were working on the case did the initial interview with her, and when she was telling her story, she started crying when she got to the point about the strip search. And I remember, because I handled the criminal piece of this case initially, and the students came to see me, and they were just, outraged that this should happen to somebody. And they said, well, isn't there something that we could do? And for anybody, how many people have had a clinical course? Raise your hand. Okay, so some of you have. So you know that when you're a law student, you go to the faculty member working with you and you say, isn't there something we could do? What should we do? The typical response that the law professor gives back is, well, what do you think we should do? And so they got to work and they put together a 1983 civil rights piece of litigation challenging what the city did, and this litigation occurred for quite some time before it was ultimately resolved when other class action cases, unbeknownst to us, were progressing through the courts, and it turned out that no, you couldn't just strip search somebody for something as minor as a driving under the influence case. But before we resolved that case, the person who was the law director, who also was an alumnus of the law school, was outraged that the law school should be representing someone suing the city that he was the law director of. So he wrote to the president of the university, wrote to the dean, wanted an explanation, how in the world could we be doing this? Unfortunately, the dean at the time, the president, backed up the clinic totally. There was another instance where we represented a dental student in a divorce matter that Ken Margolis was involved in, where it turned out that our client's spouse was represented by a lawyer who was very close to somebody who was a columnist with the Cleveland Plain Dealer, and so this columnist took it on as a cause to try to say the law school clinic shouldn't be involved in these kinds of cases. But I'm not counting those. I'm talking about major instances. And there were at least 35, 9 involving private law schools, but of those 9, 4 of them involving Tulane. So when I say Tulane's been at the epicenter, it has. I took a look at these instances and tried to see, well, how many of them actually involve the government, not just people like unhappy alumni or a columnist who's trying to stir up some kind of trouble. And I came up with 10 legislative efforts, either legislation that was introduced or passed or threats of legislation, and then 5 other instances of interventions by government actors. And actually, now that I'm doing the math here, I realize that it comes up to 15 instances, not 17. And the question, as I said before, is, well, what are the limits? And so I think to help explore that, it would be helpful to take a look at some of these to determine what kind of limits there are. So the very first instance that anyone has been able to document concerning some kind of government intervention in a clinical program occurred in 1968 at the University of Mississippi. It actually resulted in a decision in federal court, and it involved 2 untenured law professors who were working with the local legal services office in a school desegregation case in the 1960s in Mississippi. And anybody who's seen the movie Mississippi Burning knows that it's not popular in the 1960s to be doing civil rights cases in the South. And so a lot of people were unhappy, including trustees of the university. Actually, the local bar association was unhappy. And there was a lot of pressure brought to bear. And so the president of the university talked to the dean and said, we've got to do something. And the dean pulled out an outside employment policy that the university had that said that professors could do work in addition to their teaching, provided it, in quotes, did not or does not bring the employee into antagonism with his colleagues, community, or the state of Mississippi. When that went to court, it was demonstrated that there was all sorts of outside work being done by a wide variety of professors, but the only ones who had ever been targeted for this were these particular professors. And so the court found an equal protection violation. A few years later in Connecticut, the clinical program there was representing war protesters. The governor threatened to cut off funds. The dean, in response, created a faculty committee to do intake screening, basically screen out any cases that might be controversial. The clinic sought an opinion by the ABA Ethics Committee. That opinion came out and basically said that no, part of a lawyer's job is to make access to the courts available, and this type of pre-screening committee would affect the independent judgment of the lawyers, and so it should be prohibited. And then there are a number of legislative efforts. The one in Arkansas, again, which resulted in a court decision. Again, a civil rights case there. There was a rider to an appropriations bill that basically would deny funding to the university if professors would handle or insist in any way any lawsuit in any of the courts of the state or federal courts. Again, it singled them out so much that it was an equal protection violation. And then, you know, I'll sort of quickly go through. In Colorado, furor over representing a small group of people objecting to a nativity scene. There was a proposed law banning the professors from litigating against governmental units. That law was vetoed by the government. It did pass both of the houses. Another law at the University of Iowa that was caused by the clinic there doing prisoner litigation suits. In Idaho, a suit against a highway expansion. It passed the House, but not the Senate. So you'll see, as I go down to the present in terms of these laws, brings us up to the 2 most recent ones, one in Maryland, where an environmental law clinic at the University of Maryland was representing a number of small environmental groups that were challenging factory farming, chicken factory farming, and how it was polluting the waterways. The legislature had legislation introduced that would impose funding conditions, basically saying that funding might be pulled from the university. There was a lot of protest generated about the legislation stepping in that way to be punitive to the university and to the law school. And so the funding restriction was removed from the piece of legislation, but legislation was passed that now requires the law school to report on basically where it's getting its donations and how much money is being spent on the clinic. All of this as a way of trying to say, we're watching you. In fact, that's what one of the sponsors of the piece of legislation said is, okay, even though it's been watered down, the message has been transmitted, we're watching you. I'm not going to talk about the situation in Tulane because I know Adam Babich is going to do that here in a minute. There's some more threats that I have up here, and then some of the instances involving government actors. The Tennessee Valley Authority, the TVA, pressured the law school to drop a lawsuit representing some poor families that were concerned about some expansion that the TVA was doing. Again, in response to some litigation against the state, the governor in Maryland proposed that any clinic funding be contingent on not suing the state. So the policy was withdrawn, but the law school got the message. And so now the law school has a policy that any time the clinic is contemplating a lawsuit that might sue the state, they have to notify the state before actually filing suit. And another one of the instances in Tulane, and as you see a few more, the last one that I want to mention is the situation in Houston where the district attorney there refused to hire any students who'd worked on the Innocence Project at the University of Houston. He told job applicants, and he told the people beneath him, anybody who works on the Innocence Project, we won't even consider. Well, the news got a hold of that, they reported it, and so then the district attorney denied that he had that policy, and he retracted. Fortunately, he lost election, and the new DA in Houston is much better. So what's the cumulative effect of this? There have been a couple surveys, one in 2005 and one in 2007, that present what I think are the chilling effects of this. A third of clinical faculty responding have indicated that they worry about the faculty and administration reaction to their casework. 17% report that they've made some changes in the case selection choices because of their worries. Of that, 10% said they made significant changes, and 4% of people reporting said that, all of their decisions in some way are infected by this worry. A few years later, another survey showed that 15% of clinic program directors had suggested, or 15% of the clinical faculty reported that their program directors suggested to them, you really shouldn't take that case or avoid that case. And 10% indicated that the dean had suggested that they not take a case. So this is affecting the professional independent judgment of clinical faculty. So what strategies are there? Again, I think that this is really an issue of access to courts and access to justice. These attacks are what I would call in the literature, I think what everybody would recognize as extra-legal. That is, rather than litigate the cases, for example, rather than the chicken farming enterprise in Maryland, just litigate that environmental case, or rather than back in the late 1990s, the Shintech Corporation that wanted to put in this large petrochemical plant, rather than litigate the cases in court, let the courts decide, the question has been turned on, well, these are people that otherwise would never get into court unless they had lawyers, so let's go ahead and just de-lawyer them. Let's remove the lawyers out of the equation, and so the game could go forward the way it's always gone. Whatever the interests are can move forward and no one have to worry. So as I mentioned, I think that this is part of a broader war on public interest groups, including the restrictions to Legal Service Corporation, challenges on IOLTA accounts in many states the monies go to help civil legal services, sometimes even clinical programs. And those are some of the problems. Legally, I'm exploring, I think that as I said before, academic freedom as a concept is not the winning strategy in cases to try to combat this. There are issues about whether or not government can promote certain kinds of speeches in certain contexts. I view what we do as lawyers as really being, just lawyer work. It's viewpoint neutral. We're representing poor people. We're not taking a particular position. We're just advocating our clients' positions. But from a legal point of view, I think the First Amendment doesn't offer a lot of help. Of the cases that have gone to court, that have ended up in judgments that have been favorable to the law professors of clinical programs, those have typically been on equal protection grounds, which is a lot clearer ground in some instances. So I'm looking forward to the rest of the day. I'm looking forward to Adam's talk. He has a particular legal theory in a subset of cases that he wants to talk about to advance. And thank you all very much.
Wait for the low tech. Do you mind if I shut this?
Sure, sure. Though I think shutting that isn't going to turn off the screen. I'm hoping one of the AV people might help.
All right. Good morning. It's a pleasure to be here, and I really want to thank everybody responsible for inviting me. I've been extremely well treated since I've got here. This is the first time since I was in law practice that I've gotten out of the airport and been picked up in a Cadillac. So I'm a very, very happy guy. So thanks very much, and it's wonderful to be mixed up with this company, even if I've got the nagging concern that maybe the only reason I'm mixed up with this company is because I've been under attack as opposed to that I've been particularly brilliant. But anyway. First of all, having seen that clip again about Shintech, let me just give you a little bit of a postscript, which is one of the students there, Richard Ignatius, who was doing a lot of the talking, is a relatively prominent lawyer in New Orleans now, recently ran for judge. He didn't win, but everybody in town knows Richard these days. The property that Shintech wanted to build on in Convent in St. James Parish, now Nucor wants to build a pig iron plant on that very same property. And of course, we're involved. And of course, there are a lot of bitter complaints about whether or not we are driving industry away from the state. So I mean, kind of the reality of, this is the reality of environmental law, and maybe this is the reality of almost all kinds of law, is you never thoroughly win these battles. You know, you fight them away for a little while, and then they come back, right? And in fact, I've pretty much accepted, certainly in the environmental area, I figure my whole, this generation of lawyers, of public interest lawyers, of environmental lawyers, our job is to put our fingers in the dike and try to keep the whole thing from coming down on us and hope that the next generation has better ideas, that they have actual solutions. But if we can kind of get enough breathing space to continue to survive, then we will have done our job and we can pass the torch. Okay, more specifically, here's what I want to talk about, and Judy, start waving your hands around if I start going over, okay? I know that. Okay. Basically, I wanted to do three things. I wanted to describe generally my goals in terms of the work that I'm doing related to this symposium. I want to talk a little bit about Bill 549, which was the 2010 attack on the Tulane Environmental Law Clinic, and then illustrate that use that to illustrate the use or potential use, I hope to never have to do it, of the preemption doctrine as a shield or as a way of fighting back against a law like Bill 549. And by the way, I've got a draft of this paper on my SSRN page, and anybody who's interested in this stuff, I would be thrilled to get feedback, because I've got a little while before I've got to turn it into the symposium. Goals. Usually, I think about the practice of law and an environmental law as a dialogue rather than a battle, right? And even though lawyers, especially male lawyers about my age, like to talk about litigation as, you know, fastest gun in the West. I had a friend walk out of a meeting not long ago saying, we were planning. He says, my plan is to shoot hot lead at the bad guys, and he leaves the room, right? But that's not really what we do, right? This is a dispute, we're just in the dispute resolution business, right? And it's a dialogue that goes to the courts, but it's a dialogue. It's not war, it's not a battle. But, so in a way I'm describing what in some ways is a gentle person's game, right? Now, on the edges, of course, the gentle person's rules break down. I had a friend once who explained to me, after he had told me a particularly scary trick he'd used in court, and he said to me, they were trying to kill my client, doing a death penalty defense, right? So I mean, there are situations where it seems more like war than a dialogue, but environmental law is largely a dialogue. But trying to take away the other side's lawyers is out of the realm of the gentle person's game, right? That's essentially undermining fundamental values in our society for a short-term gain for your constituents. So basically, it's disreputable. It should be seen as disreputable. It's not. You know, I want to use this word, but it's so loaded now that it's ridiculous. You can't use it. It's been loaded for too long. But I mean, frankly, it's un-American, right? Because our American system is built on the idea that people have the ability to go to court and defend and vindicate their rights. The Supreme Court, as far back as 1907, said the right to sue and defend in courts is the alternative of force. We don't want people running around hitting each other over the head to solve these problems. In an organized society, it is the right conservative of all other rights and lies at the foundation of orderly government. It's one of the highest and most essential privileges of citizenship. So that's 1907. That's what people are attacking in these de-lawyering bills. And then kind of the other historical example, which has been thrown around a lot, especially in light of the conservative, or I don't know if conservative is the right word to say, but the attacks on Justice Department lawyers for representing detainees, is, you know, John Adams defended in 1770 the British soldiers charged in the Boston Massacre. I mean, this is part of our tradition, and we should not be throwing it up over the side of the boat because we would really like to build a chemical plant near somebody's community, and we really don't want to spend the extra money it takes to get an appropriate permit and potentially hire lawyers to win a battle in court. So I think one of my goals is to do everything we can, and I'm drawing on the work of people who've done a lot of really valuable work in this regard way before I got involved, including Peter Joy, but to establish this. I mean, you know, in a way, everybody knows it. We've established it academically, but to do everything we can in society, right? That, you know, the newspaper reporters, the editors, hopefully the legislators will say, this is crossing the line. And one thing along those lines is I try to look at it as much as possible in the way of de-lawyering or an attack on the clients as opposed to an attack on me or an attack on the clinics. And the reason for that is, that's what triggers those fundamental rights is the attack on the clients, the de-lawyering attempt. And you know, the real truth is, I can exaggerate this a little bit, but for me, the risk is low. I mean, in a way, I'm extremely privileged to have this job. Life is an adventure. You know, the Ferengi are trying to attack over here, and we're winning over there, and it's exciting work. Maybe sometimes a little bit too exciting, but I'm not the one at risk. If worse came to worse and they shut us down, I'd be, teaching somewhere else, I guess. But I would not, that I'm going to be okay, right? But my clients don't really have any other options. And so that's where the action really is. In two respects, by the way, especially for an environmental law clinic, it's not just, we don't only represent poor people, right? And it's not just that poor people could not afford lawyers. A lot of the kinds of cases we take are not cases that the major environmental groups would take, because they're not necessarily big precedent-setting cases. They're day in and day out, somebody's building a plant that doesn't meet standards, that is going to have a bad impact on the community, on the people next door, right? And that's generally not what kind of the big nonprofits can afford to grapple with every day. They're trying to build the law, set the precedents. So to have an institution that is, for us, of course, those routine permanent appeals, citizen suit, compliance battles are meat and potatoes, because those are great engaging projects for our students. And so to have an institution working on that is a valuable thing. And frankly, there's nobody else going to do it if we're not doing it. And when I say we don't only represent poor people, that's kind of a sticking point with a lot of folks. So for example, this Nucor litigation, one of our clients in that, it's not litigation right now, it's an administrative process. It's a dialogue, right? One of our clients in that process is Sierra Club. And one of the things we heard in the 549 battle was they're hiding behind poor people. They're representing people like Sierra Club. And kind of the subtext is we, industry, have some sort of, constitutional, moral right to be free from litigation from the likes of Sierra Club unless they're spending as much on lawyers as we are or something, right? But the truth of the matter is we could not serve our client base, which is lower income residents in Louisiana, to some extent Mississippi, Arkansas, without the help of organized environmental groups who provide often expert witnesses, who provide sophistication, and are very rarely in a position to take these cases on themselves, but can be involved in the organization and and so I guess it takes a village, right, to help communities fight the Murphy Oils of the world or the Exxon Mobils of the world. When I say fight, it's a dialogue. I'm serious. I'm not saying these are evil people, but they have different interests. Our clients live there. They should have a voice in the process, right? They should have a seat at the table. And the way we have these kinds of dialogues in the United States is through administrative processes, through litigation. Yes, it's expensive, but these are highly regulated industries. Frankly, that's part of the cost of doing business. If you're involved in a business where, for example, part of what you're going to be doing, and I'm thinking right now of an example which is a good facility, good actor. Part of what they're doing with all the state-of-the-art controls is disposing of about 40 tons a year of a known carcinogen, vinyl chloride, in the air in neighborhoods in Louisiana, right? Well, I'm sure I'm wearing some of what they produce. I'm not saying that's evil or shouldn't be done, but the people who are breathing that air deserve a seat at the table. Okay, and they can be convinced, by the way, if you meet them halfway, as opposed to try to roll over them. So, what I want to do as much as possible, it's a dialogue about the environment, but it gets to be a battle when they talk about taking my clients away. And what I want to do is gather ammunition, right? As many arguments as we can pull together that could work, because none of them are necessarily slam dunk. You know, and I'm not ready to throw them out the window, even academic freedom, which, by the way, is helpful on the inside of the university, although possibly not as helpful in court. So I want all these arguments, but none of them, especially, you know, we're facing a relatively, I mean, probably the most conservative court system we've seen since I've been practicing law, which, you know, since '84. And of course, then I moved to Louisiana, and that put me in a slightly more conservative part of the country. But basically, it's a tough environment to get decisions that build on precedent to protect people's rights. So the more arguments you got, the better. Some of them I think are pretty good, but I want more, okay? So the one I'm working on right now is basically this preemption approach. And here's the idea. And I guess to get there, really, I've got to tell you just a little bit about what Bill 549 said. So by Bill 549, this was the legislation that was intended to shut down the Tulane Environmental Law Clinic. Basically said, Tulane University, private university, so it's not a state university, we're not going to give you any more state money. Now, this is a draft. This was not enacted, right? We're not going to give you any more state money unless your clinics stop doing the following things: suing the government, mentioning the state constitution in court, bringing cases for damages. Plus, your clinics are going to be under the oversight of the House and Senate Commerce Committees. That was the legislation. So actually, part of it was conditional on funding, and part of it was just, you guys are under our oversight, okay? Now, there were some exceptions for criminal clinics, but for civil litigation. So that basically would have crippled all of us, and frankly, even, for example, I've got a colleague who runs a domestic violence clinic, and she's basically saying, hey, I just don't think I can take a case if I'm not going to be allowed to mention the state constitution. I mean, I may not mention the state constitution, but I just can't take on a case and tell a client I'm going to advocate for her and have that hand tied behind my back, right? So that's the idea of the law. Now, the condition, by the way, was not, the clinic is not state funded, and that's an advantage to us in the constitutional arguments anyway. So the state funding we were talking about are like cancer research, medical services, some endowed professorships, but I don't have an endowed professorship, okay? Not in the clinic. So things that are not directly related. And the rhetoric was very, very honest. I mean, there was no, it was no, well, we're doing this, I don't know, for some neutral purpose. They've been suing the chemical industry too often. They've even said, I mean, and I appreciate this honesty, it's their clients have been suing the chemical industry too often. They've been representing clients in these lawsuits, which of course is exactly what we do. We represent clients. It's not our agenda, right? We want to kneecap Tulane University, is what the Louisiana Chemical Association explained, because they've been suing us too often. So that was a rhetoric. We want to send a message that Tulane University, that the state of Louisiana is open for business. How, of course? By sending another message which says opposition to your permits is going to be shut down. So pretty clear legislation. So let me talk about preemption for a minute and how this fits together. And by the way, one way I got to preemption was asked to come and speak about government speech and thinking, okay, I'm going to be talking to constitutional scholars. Do I want to make a First Amendment presentation? No. Preemption is a funny doctrine, all right? And academics, I don't know, I was going to say academics hate it, but I guess they must like it because they write about it, right? But academics are very critical of the doctrine. But it's an interesting doctrine partly because it's an unpredictable doctrine in terms of how cases are going to come out. So I'm going to say there are 3 types of preemption. Now, there are law review articles out there that say it's not 3, it's 4 types. or it's even more than that, depending on what court decision you read. I learned in law school that there were 3 types of preemption. It's been working for me for like 25 years, okay? Express preemption, so Congress says state law preempted. Field preemption, Congress occupies the entire field. There's no room for state laws, regulation. And conflict preemption. The state law would stand as an obstacle to accomplishment of the federal purpose. And there are basically 2 ways that can happen. One is it's basically impossible to comply with both, and the other is that compliance with the state law would frustrate the federal purpose more subtly. So here's what we've got. We've got these very, and let me just say a few more general words about preemption. 2 basic touchstones to preemption, okay? One is legislative intent. So the real question underlying all this, so the 3 types of preemption, what the court is trying to get to is what did Congress intend to do here? But it's not the legislative intent I've been dealing with for the last 20, 25 years in the Chevron context, right? Which is the legislative intent, which basically says, which is so humble in terms of the court figuring out. It's legislative intent where the courts get to actually apply all the rules of statutory construction, look at the legislative history, figure out what the goals are. It's kind of a nice wide open inquiry in terms of legislative intent. And then 2, there is the presumption against preemption, okay? Respect for the state sovereigns, et cetera. So two basic principles. The second of which, I don't think anybody knows what it means, which is the presumption against preemption. In fact, 2009 case from the Supreme Court, the Wyeth v. Levine case, the one about a woman who had her arm amputated and basically preemption of state tort claims after there's been an FDA warning, approved FDA warning, okay, where the court actually denied preemption. But there, part of the battle between the majority and the dissent was, does the presumption against preemption apply at all? And the majority said yes. What are presumptions? I don't know how many of you deal with this still, but you'll probably all remember from law school, right? There are all these theories about presumptions. And Federal Rule 301 seems to adopt, but debatable, the bursting bubble theory of presumptions, right? That you have a presumption, I come forward with evidence to rebut the presumption, your presumption is gone, right? McCormick said, I think he took this from a court decision, these presumptions are like bats of the law, flitting into the twilight, but disappearing in the sunshine of actual facts. All right? But other preemptions seem kind of like a thumb on the scale, right? And no matter what, it's still out there. But nonetheless, if I can prove an actual conflict, I ought to be able to prove preemption, okay? So let me get pretty quickly to where I think the conflict is. Almost all modern environmental laws have some sort of encouragement for public participation. That's just part of modern environmental federal regulatory practice, is we want the public to participate. And so a lot of laws out there with a lot of variety in them. I haven't even cataloged them yet. I hope to broaden this a little bit. But 2 of them are basically all I need, I think. I'm citing the Clean Water Act and the Resource Conservation and Recovery Act. Clean Water Act, you know what that is. Resource Conservation and Recovery Act, hazardous waste, basically. But here's what Clean Water Act says. Public participation in the development, revision, and enforcement of any regulation, effluent limitation, plan, or program established by the administrator, that means EPA, or any state under this chapter, shall be provided for, encouraged, and assisted by the administrator and the states. Wow. Federal mandate. State shall encourage and assist public participation in implementation and enforcement. Right? And the Resource Conservation Act language is almost identical. What great language, right? If you've got a law which says, where the sponsors are saying, we're announcing Louisiana's open for business by shutting down public participation. And the law basically says, thou shalt not help people sue the government, i.e. participate in environmental permitting. So nice conflict, I think. Now, it's not physically impossible, I guess, to do both. But you see my point, right? That seems to be a frustration, an intentional frustration of the federal purpose. And in fact, it would be a practical frustration of the federal purpose. Now, excuse me. Lawyers, especially constitutional lawyers, are probably used to asking when they hear the federal government, when I say Congress mandated that the states encourage my participation, to saying, hey, wait a minute. Congress should just mandate that the states encourage your behavior? That sounds like a 10th Amendment problem, right? That sounds like what's a New York versus United States. Congress can't commandeer the legislative processes of the states, right? But this is all part of the cooperative federalist system under environmental law, where basically states don't have to play. And the language says, it talks about any plan, program established by the administrator or a state under this chapter, so pursuant to federal law. States don't have to do anything pursuant to federal law. It's the state's decision to come up with a program which is equivalent to EPA's programs, get EPA approval, and then operate their own programs in lieu of the EPA program. You with me? So states can say, nope, we're not playing, right? But they lose federal funding, right? They lose, and they lose control. What then EPA runs a program, preempts inconsistent state laws. Industry now has to talk to, Dallas or Washington, D.C. when they've got a problem with their permit. Nobody wants that, believe me. So in the real world, of course, states really do have to play. But New York versus United States said Congress has the power to offer the states the choice of regulating the activity or having state law preempted. And further, Congress may attach conditions to the receipt of federal funds that bear some relationship to the purpose of the federal spending. So I think we're out of the woods on the 10th Amendment. And I could, the other thing I'm looking at, which is not very complicated, is... 5 minutes. Oh, okay, good. That's luxurious. When I actually brought a preemption challenge to another state law not that long ago. When I started, I guess naively, I thought, I don't know if the preemption doctrine is self-executing. Don't I need to use 1983 or something to bring the case? Now, you can just sue under the preemption doctrine, and that presents a federal question. And the U.S. Supreme Court has ruled on that, and the Fifth Circuit's ruled on that. So we're pretty much out of the woods on that. But nonetheless, you can also probably do it under 1983. And what I like about doing it under 1983 is that I get my attorney fees under 1988. And I just emailed this morning a new article from the author of Bill 549 to Peter, which is called something like "Ambulance Chasing on the Bayou Extortion," legalized extortion, right? And his big complaint is that we settled the case, and part of the settlement was an award of attorney fees. So in a way, if we have to sue these guys, I want my attorney fees. All right. That's an interesting issue too, though, because 1983's got the C-Claimers case in the U.S. Supreme Court adopted this doctrine, which basically says if the federal statutes have their own comprehensive enforcement mechanism, you can't use 1983. Now, I can live with that, frankly. Then I'll just go ahead and use the Supremacy Clause. And I'll include a claim for both. But I don't think it applies here, because I think even though RCRA, the Hazardous Waste Law, the Clean Water Act have pretty comprehensive enforcement schemes, they don't have comprehensive schemes to enforce the Supremacy Clause. In other words, the suits that are available are not available for that. And it really doesn't make any sense, because that's not what the laws are about. The laws are about enforcing the permit obligation as opposed to preserving our right to be, to enjoy the federal, the rights granted by the federal statute without interference from the state sovereign. So that's basically where I'm going with the preemption argument. And then you can play it out a little bit more, and frankly, I don't know how much of this I'm going to do, by looking at some of the other environmental laws, say, which have sketchier, sometimes not much sketchier, but sketchier mandates to encourage and assist in state participation. And there was one case, actually, that has been lost. I was kind of surprised somebody brought it. Somebody brought a case under the Coastal Zone Management Act, which requires when the agency approves the state's coastal zone management plan, same kind of cooperative federalist system, the state develops a plan, gets it approved. One of the requirements for approval has appropriate mechanisms for public participation. And the argument was, we didn't get a chance to comment or to participate in a wind farm determination in Texas. And the court said, hey, it just doesn't say here you get that, right? It's more general than that. So that was a failed attempt to use the preemption doctrine to enforce public participation rights, but a much weaker statute than the ones that don't cover all of my cases, but they cover enough of our docket that it's hard for me to believe that you could craft a bill targeting an environmental law clinic that avoids that preemption problem. Out of time. Thank you. Excuse me.
Well, I am left with the daunting task of trying to pull what we've heard together. Those of you who have sat in this room when I've taught understand that I also am not going to use technology because you know how incompetent I am with the technology. I want to do essentially three things in the next few minutes. One is I'd like to try to put the phenomenon of outside pressure on law school clinics into some broader context. Second, I'd like to talk a little bit about some First Amendment questions that are lurking in the background here, and then I want to come back to the question that Peter Joy touched on briefly, and Adam also alluded to, the question about how does academic freedom fit into this picture. These are questions more than answers, but I think that they may help bridge this session to what follows for the rest of the day. Let's think first about putting this into some context. The idea that people in law schools who do work, take cases, get involved in public controversies, is limited to law school clinics, I think is not entirely accurate. During my first week in law school, one of our faculty, a very distinguished evidence scholar, was installed in an endowed professorship. And at the installation ceremony, he told a story about the Chicago 7 trial. It seems that one of the defendants was a graduate student at the university, and the student came to him and asked whether the professor, who was already a fairly prominent person, would represent him at trial. Now, those of you who remember the Chicago 7 trial know that some of the more prominent defendants thought that this was a political trial and that they were going to engage in guerrilla theater tactics in the courtroom. The professor told the student, I think you have a very good legal defense, but if you want to do guerrilla theater, you need a different lawyer. The graduate student decided he'd play it straight, and he was acquitted. But the case generated a huge amount of controversy in Chicago, both because of what had happened in 1968 at the Democratic Convention and because the presiding judge at the trial, Julius Hoffman, was a very prominent alum of the school. Indeed, so prominent that a classroom in the law school was actually named after him. And so the university and the law school were subject to a lot of pressure from people who were outraged at the very idea that a member of the faculty would be involved in such a case, and making all manner of dire threats about withholding funds and other things. And as the professor said at the installation ceremony, to their everlasting credit, the dean of the law school and the president of the university told all of those people, in effect, to go jump in Lake Michigan. I'm sure there are other stories like this around, but it does seem to me that we should remember that it's not just clinicians who can, and clinical students, who can get into controversy. So that's one piece of the context. Second piece of the context, both Peter and Adam have talked about the notion that attacks on law school clinics are, in effect, attacks on people who would not otherwise have legal representation. So by de-lawyering their efforts, it is possible for people who want to go forward with various projects and policies to do so with relatively few obstacles. This also is not new. Last Sunday was the 50th anniversary of the Supreme Court decision in Gomillion against Lightfoot, which was the Tuskegee gerrymandering case. But Gomillion was decided and arose during a period of great efforts by various Southern governments to try to kneecap the civil rights movement by making it impossible for the NAACP to function. The theory was that the NAACP was stirring up trouble among otherwise happy people who were being led down the primrose path. So, for example, in Alabama, the legislature passed a bill requiring the NAACP to turn over its entire membership roster, or its entire in-state membership roster, to the state, on the theory that the NAACP might have been infiltrated by communists and other subversives. So the state, on this view, was doing a service to the NAACP by helping them to root out these bad people. Well, of course, everybody understood that the whole point of the exercise was to give the state and private groups acting in league with state officials the opportunity to harass people who belong to the NAACP. A number of states passed laws prohibiting members of the NAACP from serving as public school teachers and holding other kinds of public employment. And Virginia, to get back to the analogy here, Virginia passed a law that essentially tried to bar the NAACP from participating in litigation on the theory that the NAACP was controlled by lay people, and therefore if the NAACP was conducting litigation, the organization was engaged in barratry, and the citation for this is NAACP against Button, in which the Supreme Court struck down that law. So we've got that example. And then at a more general level, Peter talked about, if you remember, if we're old enough to remember these things, well, some of us may also be old enough to remember the old Community Action Program, which was at the center, it was one of the centerpieces of the war on poverty in the 1960s. Well, the Community Action Program didn't do a lot of litigation, but it stirred up a lot of political trouble for some politically prominent folks like Mayor Daley in Chicago and people elsewhere. And eventually, the Community Action Program was domesticated or defanged or whatever. But again, the theory was that this was a device for empowering people who were relatively powerless, and that served as a kind of threat to the powers that be. So when we think about the pressures that law school clinics face, we ought to think about them in larger context. This is not new. It's a variation on a theme that has been with us for a while. Now, let me talk very quickly about a couple of First Amendment cases that might bear on at least some of the work of some law school clinics. First, when we think about public law schools as opposed to private law schools, we need to think about Garcetti against Ceballos. Garcetti against Ceballos is a 2006 Supreme Court decision which basically says that public employees do not have First Amendment rights against discipline or regulation when they speak on matters relating to their employment. The opinion is written quite broadly. The case actually involves an assistant district attorney in Los Angeles who got in trouble internally for questioning the adequacy of the documentation underlying an application for a search warrant. But the Supreme Court said that because he was speaking about the search warrant and the evidence in connection with his official duties, he didn't have First Amendment protection against discipline. It's not clear how broadly we should read Garcetti, but we ought to be sobered by the fact that although Justice Kennedy's opinion says we are not addressing whether the rule we lay down in this case applies in academic institutions, lower courts have generally taken a very cramped view of the First Amendment rights of teachers and professors. Earlier this year, for example, the Second Circuit decided a case in which a New York City school teacher was fired because he had filed a complaint that his principal had not adequately backed him up in connection with his efforts to deal with a disruptive student. He didn't get anywhere with that, so he filed a grievance. For filing the grievance, he was fired. The Second Circuit says under Garcetti, this is related to his employment, and therefore he has no independent First Amendment protection. Now, how much beyond that we will go, who knows? Sitting in the back of the room is one of our Law Review associates who was actually writing his note this year on precisely that question. And so let's just say I will look forward to seeing what you come up with, Ben. Okay. Okay. So there's at least some question about whether clinical teachers at public institutions could assert some kinds of First Amendment defenses, given that what your job is as a clinician is to go out and work with students and represent clients. So a broad reading of Ceballos might suggest that the First Amendment offers little or no protection for clinicians at state institutions. Whether we're talking about public or private institutions, some clinics receive some government money. And to get us back to the government speech theme, the government might assert that restrictions on what clinicians or law school clinics can do to the extent that they are publicly funded might involve government speech. That is, the government has a message that it's trying to convey, and under cases like Rust against Sullivan, the government has the power to limit the speech of grant recipients to make sure that the money that the government provides is going for its intended purpose. There is, however, another case that may be helpful on this one, and that is Legal Services Corporation against Velazquez, which was decided in 2001. The Legal Services Corporation, for many years, and there's been, Peter alluded to this earlier, the Legal Services Corporation for many years has operated under legislation that limits the kinds of lawsuits that legal services funded agencies can bring. Velazquez challenged the provision that prohibited legal services funded agencies from challenging welfare laws and regulations. It wasn't quite as sweeping as this bill that, the 549 to which Adam alluded, but I guess under that restriction, you could mention the Constitution, you just couldn't do anything with it. Legal Services Corporation argued under cases like Rust, well, this is government speech, we can limit the uses of the money. The Supreme Court says, not so fast. It is true that there is government money here, but it is also clear that this money is not being spent to convey the government's message. Rather, this is a form of subsidy of private speech, and therefore the restriction on the kinds of welfare cases that can be brought violates the First Amendment. So if Garcetti is a bad sign for First Amendment protection for law school clinics, Velazquez at least suggests that there's something on the other side. And maybe we can talk more about that in the next few minutes in the discussion and through the rest of the day. I want to take just a couple of minutes to talk about the academic freedom argument because, as Peter said, the Supreme Court has a line of cases in which it says that academic freedom is a special concern of the First Amendment. What's interesting is that in many of the cases in which the court rules or says that academic freedom is an important First Amendment value, the claim gets rejected on the merits. Academic freedom is a very complicated subject. It does obviously have First Amendment concerns, but it's complicated in a number of ways. There's an individual component to academic freedom, that is, what an individual teacher or scholar can do in the pursuit and dissemination of knowledge, but there's also an institutional side of academic freedom. That is, to the extent that academic freedom is an institutional phenomenon, it protects the institution from external constraints. And for law school clinics, it's the institutional side that really matters. But even on this side, it seems to me that the question about how academic freedom plays in the law school clinic context is complicated. And it's complicated because of the nature of law schools, not just clinics. The overwhelming majority of American law schools now are affiliated with universities. Still some freestanding ones, to be sure, and some fine freestanding law schools, but most American law schools are part of universities. We also have a kind of odd relationship to the university. We are not the kind of classic science or hard science or natural science or humanities discipline where we're just out to find and produce and disseminate new knowledge. We're also in the business of training lawyers. Any of you who have been both to graduate school and to law school will know that there is a huge difference between what happens in law school and what happens in graduate school. And it's not just that we have huge classes and the professor stands in the front of the room posing a bunch of unanswerable questions. The fundamental difference, I think, between law school and graduate school is that in graduate school, the presumption is that all of the students want to grow up to be like the teachers they work with. Doesn't always happen, but that's kind of the presumption in most graduate programs. In law schools, even law schools that produce a significant number of law teachers, the great majority of the students never go into teaching. The idea is we're going to go out and do something different from what the teachers are now doing, even if what we will be doing is what the teachers, or a lot of them, had done at some point in their professional careers. And so that seems to me to at least raise the question, what does it mean to talk about academic freedom in law schools, and particularly in clinics? I don't raise this to say that it's clear that even if academic freedom applies only in a limited way in law schools, that therefore external forces should be able to make whatever sorts of regulations they want. I simply want to suggest that whatever it is that law schools are about, it's not the same thing as what the biology department or the math department or the political science department or the history department or the English department is about. And so as we think about how academic freedom applies and whatever First Amendment component it has, that First Amendment content is more complex, it seems to me, than the way academic freedom plays out elsewhere on campus. Maybe doesn't lead us to a different outcome, but at least makes the path to arguing that external restrictions on law school clinics are sufficiently suspect that we resort in the first instance to arguing that we have academic freedom problems. I haven't sorted out how I think about these things. I think that these issues are hard, and I think that may be one reason why, as Peter says, the cases that have challenged external restrictions, to the extent that they've won, they've tended to win on grounds other than the First Amendment. So perhaps I've done my job as a law professor by asking more questions than I've answered. I'm looking forward to the rest of the discussion, and thank you for your patience. So.
We really did want to give everyone an opportunity to participate, but maybe first, if Peter or Adam have any response.
Right. Actually, I do have one response on one thing with John. I was always, as a law student, the kind of student that didn't necessarily agree with everything a professor said. So, and I basically agree with everything except one piece, which I didn't make clear, and I'm hopeful that there'll be some progress in this. But when John said that a law school clinic and law schools aren't exactly like the biology department or English department or something like that, I think you're basically right. But I like to think of the law school clinic like the biology lab, all right? The same way that you might have some kind of biology course without a lab, which would be the rest of law school courses. And in the lab of the law school, the cases that we have, the clients that we have, that's really the textbooks that we're working from. And so the choice of cases, as long as they're within whatever the clinic you have, like Judy works in the criminal justice clinic, that those kinds of decisions are the same kind of decisions as choosing a textbook. Now, this isn't some crazy idea. And the reason why I say it isn't a crazy idea is at least the AAUP has taken that position. Now, of course, I was writing an amicus brief for the AAUP in which we advanced that position, so it could be that I've infected that notion. But I'm hopeful too that in a recent article that's coming out in the AAUP magazine Academe, Bob Kuhn and I suggest that what's happening to law school clinics, could be something, we use the word like a bellwether for what might be happening to service learning courses and other kinds of courses. And there are some other instances. So, for example, labor courses in different departments, more academically oriented departments, or social work activities that students do where they might be doing some work with a community group, confront some of these same kind of questions. So the issue about academic freedom, not as a legal concept, but as a as a norm within educational institutions. And I want to make that distinction because academic freedom as a norm in educational institutions is a much stronger position than a concept in terms of a First Amendment right. And in that context, I think that what we find is a movement that academic freedom should be protected wherever teaching occurs, whether it's in the classroom, whether it's in the lab, whether it's in a service learning course, whether it's in a practicum of a particular field. And so it's not to say that I disagree with John, but it's just that I wanted to add that little bit more piece of information or nuance to, I think, what John was saying.
And let me just add, I mean, my focus was more on what a court would do with the argument.
Okay.
I think those of us who do constitutional law generally, I think, know that the Constitution has meaning that arises outside of courts as well as inside courts. And so, yeah, we need to recognize that, in a way, we've lost if these issues are in court. The way to really, and you know, that was the point of my telling the story about the professor with the chair, that if he can't count on support from the university, then even if he wins a lawsuit, his situation is very different.
Adam, did you want to
No,
jump in here? Okay. Yes?
Well, since I am a First Amendment person, my question is a First Amendment question. And it's along the lines of, what do you think of this? And it seems to me that Garcetti might be limited to the employer-employee context, since supposedly the justification for it was to give the public employer some of the same power that private employees have in disciplining employees that might be like disruptive to the efficient functioning of the workplace. And given that, maybe Garcetti isn't such bad news for this kind of situation.
Well, let me flesh this out a little bit. I mean, I think that may well be right. On the other hand, the legal profession is pervasively regulated by external agencies, particularly state Supreme Courts. I mean, you know, part of what strikes me as problematic about what 549 is that it came from the legislature, but you know, as you indicated, there were strict rules put down by the Supreme Court. It seems to me, not that Garcetti by its own force leads to the conclusion that clinics may be vulnerable, but rather that this notion that the clinic as part of the profession is subject to external regulation may provide at least a little push for the argument that the court might be able, the state Supreme Court might be able to impose restrictions. I don't want to push this too far, as I said, because I agree with you that Garcetti is about something else. It's about the workplace. But it does seem to me that Garcetti, whatever you might say about it in general, reflects a notion that what people do in the workplace should be subject to some kind of hierarchical regulation. And that seems to me not necessarily to be a good thing.
Yes.
To follow up on Professor Corbin's comment, I think I agree with her interpretation of the case, but I also think that the Velazquez case, which is what I was thinking of from the first moment you got up there, is probably going to be very, very helpful because it is so much more specific to protecting the client-lawyer relationship. And in fact, of course, at the time, it was so surprising a case because Rust had just come out the other way, but they found, as justices, something very special about protecting that relationship. One thing I was kind of intrigued by is you said that some of the work that you do in Tulane is simply kind of day-to-day work versus this global issue. We're going to fight this new business that's coming into town. And I'm kind of surprised that the government didn't distinguish at all between those two types of cases. Because, of course, in the Velazquez case and what comes up a lot in the federal efforts to squash this kind of work is they don't have to do the issues work, and they thought it was fine to do the poor representation. So I'm curious if there's ever been any kind of distinction drawn by the legislature, or they're just out to get you all the way, no matter what you're doing.
Mm-hmm. Well, and by the way, I think I don't know how any of these cases work going forward, because we had Justice O'Connor for Velasquez, right? And so the world changes, right? But nonetheless, hopefully it won't be up there too soon. But I think it works much better for an argument like you're not allowed to mention the Constitution for a provision like that than it does for a provision which says something like you're not allowed to sue the government at all, right? I think. And now I think there are other problems with that, especially when it's not, then I think it's more of a First Amendment problem, I think, when the government doesn't actually fund the program at issue. But in terms of the kinds of work we do and the legislature drawing a distinction, I think from industry's perspective, and I should use that too broadly, because I've had people from big companies say to me, "Keep doing the kind of work you're doing," So it's not like it's a universal thing, right? But from the Taliban group of the industry, really anything which slows them down is evil. And so it doesn't really matter whether it's a precedent-setting case. If we're commenting on a permit and DEQ may stop, and DEQ is the Department of Environmental Quality in Louisiana, may stop and say, gee, we need a little bit more data to understand, those emissions based on these comments, then from the Louisiana Chemical Association's point of view, we have slowed down the permit and risked investment in the state of Louisiana, and that's just a terrible thing. So basically, they are against public participation in the permitting process. And that's the daily routine work we do.
And if I could add one thing, because although I didn't talk about the First Amendment cases, when I said things were murky, I meant it because I've read all of them. And so I'll use Velasquez to show you why, on the face of what you said, I think you're right, but if you dig a little bit deeper into some of these attacks, it doesn't come out the way I'd like it to. And the reason is this. In Velasquez, the court said, well, Congress doesn't have to fund a legal services corporation, but if you do, then there are some limits. So a lot of the legislation that's been proposed, and fortunately not have passed, would just totally deny funding. And that's something the state legislature could do. And now to move on to something that John referenced about the Supreme Court in their control of things. There was a case, I was on one of my slides, a Southern Christian Leadership Conference versus the Louisiana Supreme Court that went up to the Fifth Circuit. And in that case, what was being challenged were these more restrictive rules put on what law school clinics could do, kinds of clients that, well, actually not what they could do, but the kinds of clients they could represent.
Well, the solicitation.
In the solicitation,
right.
Well, a provision that if law students did a public interest information meeting about rights that people had, then they couldn't represent the individuals who might have gone to that meeting.
Although it didn't actually say that. It basically said if we solicited a case,
right,
we could not assign a student to the case. So it burdened, if we exercise that First Amendment right, if you accept that, to solicit a case, we can't assign a student to the case.
Yes, but I don't want to get into dispute, but the idea of do you solicit a case when you tell people you have these rights, and if you want representation, come to see us, or not, but without delving into the facts of that. Going back to what happened, it was very clear, and the court accepted, that in the district court dismissed this on a motion to dismiss. And so, the standard on review, everybody remembers this, on review you have to accept the facts that were alleged. And there was an allegation of viewpoint discrimination. And the Fifth Circuit opinion says, well, even if the court did this in response to the pressure that the plaintiffs have alleged. They have done this in a viewpoint neutral way, and they've only done it prospectively. They've made it clear it doesn't affect any of the pending cases. And so even if there was bad motivation, in this instance, it's not going to count. Now, they did say, the Fifth Circuit did recognize that this bad motivation in other areas of the First Amendment could be the lever that you could grab a hold of to try to get something declared unconstitutional, non-permissible. But in this context, that wasn't enough. So the only reason I'm pointing those two things out is that Velazquez, on the face of it, might provide some help in some types of legislation. That's the point that John made when he was talking. But there are other types of legislation, total defunding, that becomes more problematic. And also, although the legal profession is subject to the regulation of the Supreme Courts, when they act in this legislative role about the rules that they make, I think that the Fifth Circuit decision, provides a little bit of a blueprint for if Supreme Courts, which primarily are elected in most of the states, I think 38 states, that if they were to be the pressure points as they were in the late 90s, that they might enact some restrictions that would be viewpoint neutral, would only apply prospectively, and that might provide some constraints. I think what the clinics in Louisiana have done is remarkable, because they've demonstrated that even within the number of restraints, the needs are so great that there's so many cases that are able to be handled, so many people that have justiciable claims that need to have those claims heard, that in reality, I think it's proven not to be the barrier that was feared, and so it's I think that's been great. On the other hand, because it hasn't been the barrier that industry wanted, they continue to come back with other ideas like Bill 549.
Mm-hmm. Could I just say a quick word about that case? I think this is the Southern Christian Association case. Fifth Circuit, one of the interesting things about the case is an illustration of something I tell my students about a lot, in my view, okay, and other people may differ with this, which is almost winning by losing, right? In that the plaintiffs in that case, who were clinic clients, some professors, lost the case on the merits. They got, they lose. But through the course of it, the Louisiana Supreme Court filed this trove of briefs explaining, this is why the rule regulates way more lightly than these folks are telling you it does. So essentially, in the best post hoc legislative history in the world, which is the Supreme Court telling the Fifth Circuit, and then on a cert petition, which was denied, but telling the Supreme Court, here's what the rule means. Essentially, they were saying, hey, this rule doesn't mean too much, right? These are the limitations. It's very narrow. And then as the rule was implemented in the state courts, all that stuff was actually very useful to me. So things that could have been read either way before that Fifth Circuit case were read consistent with the way the Louisiana Supreme Court had interpreted in that case.
Yes.
Yes, there are. It seems as if there are law clinics that the government likes to exist. Like the government may not have any objection to. In fact, that they may like law clinics that where the students help to prosecute international criminals and terrorists and things like that. So if the government likes some clinics, openly supports some clinics, but yet opposes other clinics by saying that it doesn't make their locality open for business, or I mean, isn't there cherry picking of the clinics, and shouldn't some clinics have the same rights as all the others?
Well, that's actually something that the committee members, when Senate Bill 549 was heard, at one point Senator Adley said, because there was all this talk about, well, how can we run a domestic violence clinic if we can't mention the Constitution? And Senator Adley said, hey, I'll amend the bill to only talk about the environmental law clinics, he said, public or private. Of course, there's only one environmental law clinic in Louisiana. And one of the committee members said, well, wait a minute. Now, so we solve your problem for you, and then somebody comes to me and says, I'm getting a divorce and my wife's not paying for a lawyer. Instead, they're getting these students, or the DA's office comes to me and says, these students are filing all these crazy motions in our criminal cases. What do we do then? You know, and so the Senate committee, that came up, and they seem to be taking that seriously, that if we're going to take people's lawyers away, if that's really the appropriate thing to do, why shouldn't we just take people's lawyers away instead of only doing it when it affects the chemical industry?
I think that'll be the last question right here.
Well, I'm wondering, since bar associations spend a lot of effort to encourage pro bono actions, have there been a likewise or any actions by bar associations, particularly in states like Ohio, where bar associations will investigate disciplinary matters, of looking at actions of governmental lawyers who use their power not directly to fight in a courtroom for under advocacy issues, but indirectly, threatening lawyers that your employer, your university will face my wrath if you take these actions. I'm wondering if these have resulted in any disciplinary actions by bar associations that are encouraging the pro bono activities.
Okay. Well, I don't know of any disciplinary actions, but everybody who's a lawyer knows that bar investigations, unless they end up with some kind of public reprimand or public discipline, don't ever become public. I do know, kind of along the lines of your question, that both with the Maryland attack and also, I believe, with the Louisiana attack, though Adam could correct me if I'm wrong, but I know for sure with the Maryland attack, Carolyn Lamb, who's the president of the American Bar Association, wrote a very strong letter of support for what the clinic was doing. I remember that the time frame with Louisiana was a little bit short, but I believe that she did also. Sure did. She did, got that there, that so that the ABA has been very helpful. And I know that at different times there's been some support for the clinics in Louisiana from the bar associations in Louisiana back in, the 1990 matters. And I guess you could speak to that more in terms of what happened in 2010.
Right. In fact, our first witness in this committee meeting hearing was the president of the Louisiana State Bar Association, who personally had appeared on behalf of a defendant in court on the other side, and her testimony was, "Don't do this. This is not appropriate." And in fact, by and large, well, really without an exception, to my knowledge, now I've got no idea what everything that happened behind the scenes, but I thought the bar behaved very, very professionally throughout. I did not see the lawyers piling in and coming up and saying silly things. And in fact, right after the incident, the New Orleans chapter of the Federal Bar Association awarded the clinic its pro bono award for the year. So I feel the bar was very supportive. Now, Bob Kuhn, I don't know whether you were a co-author, wrote an article about using,
that's right.
About using, basically about whether or not lawyers who try to de-lawyer clients should be subject to discipline, which is an interesting article, but I view it mostly as interesting as something lawyers should read for their own self-reflection, in that, I think part of what's important in kind of making this process work is for the bar to view us in the clinics as part of them. We're helping them accomplish a purpose, which is pro bono representation. We're part of the club, in a way. We're one of their colleagues. And I think you have to be careful about making the decisions about when to file disciplinary complaints, in that you can blow things up so that it's no longer a dialogue, it's a war, right? And as much as possible, I would like to see the bar basically stick together in these things. Obviously, the lawyers who directly represented the people who were attacking us were silent, but they were silent. They did, in other words, they weren't lobbing grenades.
Thank you. I think we have to end. I really want to thank the panel, and I know this conversation is going to continue all day.
Thank you.